Good evening, everyone. Thank you all for joining us. We'd like to welcome everyone from AmCham Kuwait, AmCham Abu Dhabi, AmCham Bahrain. This event's being done in coordination with one of our Chairman's Club members, Al Tamimi and Company, with the support of the AmCham Abu Dhabi and AmCham Bahrain. We're really excited about this. You're in for some great information on international arbitration. It's going to be led by one of our former board members, but still a great contributor to the organization, Mr. Philip Katzis. He's the partner and head office in Kuwait for Al Tamimi. And the other speaker will be Thomas R. Snyder, partner and head of arbitration. I don't want to talk too much. Please keep your microphones on mute and type your questions into the chat box. Once we finish, we'll get back to your questions. But again, I can't say enough great things about this gentleman before I turn it over to him. His contributions still echo on the board, and I'm always excited to hear anything he has to say. So I'd like to turn it over to Philip. Thank you very much.
Thank you, Pete. That's far too kind. Not sure I'm deserving of all those accolades and praise, but thank you so much. And it goes right back to you, Pete, and the entire board there. Great people, great organization. So thank you so much for that. And thank you to ABCK-Kuwait, AmCham Abu Dhabi, and AmCham Bahrain. You know, it's always such a privilege to participate in these ABCK-AmCham events. It's truly a great platform for both, U.S. and regional companies to network and be able to get together and discuss the topics that are most important, relevant, or interesting to us in Kuwait and throughout the GCC. As Pete stated, my name is Philip Kotis, and I'm a partner and the head of the Kuwait office of Al Tamimi Company. Al Tamimi is the largest regional law firm in the Middle East, and we have 16 offices located across 9 countries in the GCC and Middle East. And one of the benefits that we're able to offer our clients is access to specialist lawyers spanning a number of different legal sectors. And today it's our pleasure to focus on one of these legal sectors, specifically regional updates in relation to international arbitration. We're delighted to be able to speak with you on this particular topic, given the importance of arbitration in relation to international business dealings. Whilst the GCC and the other Middle Eastern countries often share similar legal and cultural backgrounds, given the nuances of local laws and coupled with the far greater differences in common law jurisdictions such as in the United States, Europe, and the United Kingdom, parties seek to find greater certainty in relation to their disputes that may arise in their agreements. The use of international arbitration has evolved to allow parties from varying legal, linguistic, ethnic, cultural backgrounds to finally resolve their disputes, and generally without the need to rely on the uncertainty and the formalities of local judicial systems. And so these are some of the reasons why it's such a good topic to discuss and relevant to the GCC, given the different countries and the fact that we have, groups like AmCham that have members from all across, the region and the United States that are doing business throughout these jurisdictions. It's so important because it's a way to kind of centralize oftentimes these type of agreements instead of worrying about the nuances of the laws in particular countries. They can agree to have some more say over how their disputes get dealt with, and that's very important. So, well, that's enough for me for now. I could probably go on talking forever and ever, and I will come back into it in a little bit to discuss some things about Kuwait in particular. But I'd like to introduce really the man of the hour now, which is Mr. Tom Snyder. Tom is a partner at the firm Al Tamimi and heads up our arbitration department that's and he is based in the Dubai office. He's got over 20 years of experience in international arbitration in a variety of sectors and industries. Tom has been, recognized for arbitration, dispute resolution, and Chambers and Partners, Who's Who Legal, and Nexology's Client Choice, and is a member of the Court of Arbitration of the Singapore International Arbitration Center, the International Arbitration Committee of the Korean Commercial Arbitration Board, and the Arbitration Committee of the Lagos Court of Arbitration. Tom is a U.S. qualified lawyer who's been based in Dubai for 5 years, and prior to locating to Dubai, he was based in Washington, D.C. So without any further ado, Tom, you can take it away.
Okay, great. Thanks very much, Philip. And good evening, everyone. I'd like to thank Pete and Paula and the rest of the team at AmCham Kuwait, AmCham Bahrain, and AmCham Abu Dhabi for this opportunity. Really excited to have the chance to speak with you this evening about international arbitration. As Philip said, there are a lot of benefits for commercial parties in using international arbitration. We'll talk a little bit about that in the coming little while, and some very interesting developments in the region and more broadly. I think we go for about 1 hour, but I'm going to try to save some time for Q&A. And if you have any questions as we go, do feel free to add them to the chat box, and we'll try to get to them at some point during the presentation. I hope you can see the slides on the screen here. We're going to sort of start off. I don't want to get too academic, but I want to provide sort of a brief refresher course on international arbitration. So we'll talk about exactly what it is and why parties use it. We're going to talk just briefly about the New York Convention, which is the international treaty that really makes the international arbitration system work as effectively, I think, as it does. We'll talk briefly about national arbitration laws and the importance they play in implementing the New York Convention in a particular jurisdiction. And we'll also talk a little bit about the concept of the seat or place of arbitration, which comes into play when you're drafting arbitration clauses and you have an arbitration. We'll talk also briefly about institutional arbitration through the ICC, LCIA, and other arbitral institutions, and use that all as sort of background to get to what I think is sort of the main point of the evening, and probably the point we'll end up spending the most time on, even though it appears as point number 5 here on the screen, and that is the recent decree in Dubai that has impacted, let's say, the DIFC-LCIA arbitration center, which certainly many parties here in the UAE, but in the broader Middle East, including there in Kuwait, have used in their arbitration clauses in the past. And we'll talk a little bit about the impact of that. So if we jump right in and march ahead, as I talk to clients, there are certainly times where I get the impression that there's a tendency to sort of lump arbitration in with other forms of dispute resolution, namely mediation and conciliation. And while they are all three alternative forms of dispute resolution vis-a-vis the primary form of dispute resolution, which is the court system, litigation in the court system, I think there are pretty significant differences between arbitration and these other forms of ADR. And I think the key point here is actually the last point on the screen. That's where I'm going to start and maybe work backwards. And that is just to remind everybody that unlike mediation, where you have a mediator that tries to go between the parties and reach some sort of commercial solution, arbitration is very much an adversarial form of dispute resolution. If you look at arbitration, the procedures and the approach are much more similar to litigation than they are to, say, mediation. With that said, it's important to bear in mind, and I think Phil might pick up on this point a little later on, but it is important to bear in mind that because it is an alternative form of dispute resolution, the parties have to agree to it. The parties have to agree to sort of give up their rights to the local courts and proceed with arbitration for resolving their commercial disputes. So it's always the product, arbitration is always a product of an agreement between the parties. It's the submission of a dispute to a neutral decision maker who is not a judge, although frequently retired judges do act as arbitrators, and it results in a binding award that is enforceable on the parties. And we'll spend a little bit of time talking about the enforceability of arbitration awards in Kuwait and beyond. Now, I did say earlier that arbitration, generally speaking, is much closer to litigation than it is to mediation. But I think one of the things that distinguishes arbitration from litigation is that the procedures are more flexible. The parties can agree on different approaches. They can agree to expedited proceedings. They can agree to document-only proceedings, so long as the parties are treated equally. So much more flexibility in arbitration than we see in litigation. If we move to the next slide, the next point I'm going to address is, why do parties use arbitration? Why do they like it? And I've already alluded to that to some degree in the last slide, but I think this is an interesting bit of information from a recent survey that was done by Queen Mary University of London in White and Case, in which they interviewed corporate counsel. And the results, they interviewed corporate counsel as to what their preferred dispute resolution mechanism was for cross-border disputes across industries. And really overwhelmingly, international arbitration emerged as the preferred method of dispute resolution amongst corporate counsel. 59% listed international arbitration together with some form of ADR as their first choice. So we often see in arbitration or dispute resolution agreements that the parties first try to resolve their dispute through mediation, and then if that is not effective, move on to arbitration. So that's what this first point is. The second was 31% listing international arbitration as a standalone dispute resolution mechanism as their first choice. So with these two choices combined, we're talking about 90% of the respondents saying that international arbitration was their preferred choice, and only about 8% listing litigation and 2% listing ADR, presumably mediation only. So why do we get results like this? Why do parties prefer international arbitration? I think there are several reasons. And I also think it depends to some extent on whether you're talking about international arbitration involving parties from different countries, different jurisdictions, or if you're talking about domestic arbitration. Because I think while there are a lot of similarities between international arbitration and domestic arbitration, there are some key differences, and I think some fundamentally different starting points. If we look at international arbitration, the reason parties use it, I think, are primarily the first two reasons listed on the screen. The first is the enforceability of arbitration awards around the globe, and we're going to talk about that in more detail in a few minutes in the context of the New York Convention, which really gives a lot of teeth to the enforceability of arbitration awards. But I think the other factor as to why parties use international arbitration is the concept of neutrality. If you're an American company investing in Kuwait, you may not be familiar with the procedures in the Kuwaiti courts. Vice versa, if you're a Kuwaiti investor in the United States, you're not familiar with the US courts. You may not be comfortable with the broad notion of document discovery that we have in the US courts. And so the two parties agree to arbitration to have their disputes resolved by a neutral decision maker. Now I'm going to come back in just a moment to the next 3 points, but I want to jump to the last 2 points, because I think when you're talking about domestic arbitration really emerged as an alternative to local court litigation. And there is an emphasis on time savings and cost savings when you're talking about domestic arbitration. Parties want the dispute resolution process to be faster and cheaper than the court system, and so they use domestic arbitration. That sort of begs the question of, do these factors of cost savings and time savings apply to international arbitration? And I think the answer is yes, they do. But it's important to bear in mind what I said a few minutes ago. International arbitration didn't arise as a form of dispute resolution that was supposed to be cheaper and faster. It arose in order to stay out of the courts and take advantage of this enforceability mechanism. With that said, with the growth in trade and commerce and investment across borders at varying levels, I think it really is important for international arbitration proceedings to focus on time-saving and cost-saving mechanisms. And it's probably a topic for another day, but we are increasingly seeing in arbitration rules of various arbitral institutions across the world, more innovative mechanisms to speed up the time it takes to do an arbitration and hopefully to save costs as well. The three factors in the middle, I've already alluded to these in a couple of these in the opening slide, but that ability to choose your decision maker. If you want a lawyer or a retired judge to resolve your dispute, you can select that person as your arbitrator. If you want an engineer or somebody with technical experience and expertise, you can choose that person. Whereas if you go to courts, you're often stuck with whatever judge is assigned to your case, and often he or she will be more of a generalist. I've mentioned procedural flexibility and also confidentiality in some cases is a reason why parties like to use arbitration. If we move on, I've already alluded to the New York Convention. I won't spend too much time on this, but this international treaty is really what makes international arbitration work and work so effectively. The New York Convention first came out in 1958. It's over 6 decades old at this stage. It's sort of time-tested and works well. It's been ratified by 169 countries around the world, including all of the big players, United States, European countries, most if not all of the countries here in the region now. The most recent party to ratify the New York Convention was Iraq, and the New York Convention just came into force in Iraq about a week and a half ago. So it is now a party to the New York Convention. I think they ratified it in November and it came into force just this month. The New York Convention, it's not a long document, about 7 pages, and you can really boil it down to 2 primary obligations. It imposes an obligation on state parties to recognize and enforce arbitration agreements and to recognize and enforce arbitration awards, subject to very limited exceptions. And I think this is important. The only means of challenging an arbitration award under the New York Convention are the grounds listed here. And I'm not going to walk through each one, but broadly speaking, I sort of organize them into 3 categories. You can make jurisdictional objections, procedural objections, and public policy objections in order to challenge an award, an arbitration award, before the courts. What you cannot do is to seek to challenge an arbitral award on the merits of the award. So it's only on jurisdictional, procedural, and public policy grounds, broadly speaking, that you can seek to challenge an arbitration award, which really adds to the finality of the arbitration process. Now, with that said, certainly parties do try their best to challenge arbitration awards in courts. And I would say we see that, I'm speaking in general terms, but I think we see more of an effort to challenge awards in the courts here in the region than we do in other parts of the world, often on very technical grounds. And certainly there are some grounds here in the region where parties have had some success in challenging arbitration awards. And I think Phil will pick up on that a little bit later in the context of specific authority. The New York Convention is really the big player when it comes to international arbitration across the globe, but certainly some regional and bilateral agreements do come into play from time to time when you're talking about the enforcement of awards. Here in the region, one example of that is the Riyadh Convention. If we move to the next slide, I just want to say a few words on national or jurisdictional arbitration laws, and I'll explain in a moment why I've said national or jurisdictional laws. In order to implement the New York Convention into the legal system of a particular country, that country will, of course, need its own national arbitration law to implement those broad obligations in the New York Convention. Most countries will base their national arbitration law on the UNCITRAL model law on international commercial arbitration. That's sort of the gold standard of arbitration laws. It's as its name implies, is a model law developed by the UN Commission on International Trade Law to sort of set out best practices in this regard. Over 80 countries have adopted some version of the model law. Often you see countries sort of tweaking it around the edges, but most countries will adopt it, if not wholesale, largely wholesale. And the national arbitration law will cover each step of the entire arbitration process, from the recognition of arbitration agreements through the arbitration proceedings. Of course, AmCham Bahrain is one of the sponsors of today's event, and it's interesting to look at what Bahrain has done. Bahrain has a very short, about page-and-a-half arbitration law, and effectively what it does is adopts the UNCITRAL model law word for word. It basically says that the arbitration law, the international arbitration law of Bahrain, will be the UNCITRAL model law, and clarifies a few issues. So Bahrain, when it comes to international arbitration, really went all in on the UNCITRAL model law. Now, in the title to this slide, I say national or jurisdictional arbitration laws. And one of the reasons I've done that is that, you know, within a particular country, you may have multiple arbitration laws. We see that in the US, for example. You have the Federal Arbitration Act, and then many states will enact their own arbitration law as well. We have a similar sort of thing here in the UAE, where we have 3 arbitration laws. We have the federal law on arbitration, which came into force in 2018 and is broadly based on the UNCITRAL model law. But we have 2 free zones here in the UAE, the Dubai International Financial Center and the Abu Dhabi Global Market, each of which, as many of you probably already know, have their own set of commercial laws, largely based on English law, and this includes their own arbitration laws. The DIFC law number 1 of 2008 and the ABCK-AmCham arbitration regulations of 2015. Here again, both of these are largely based on the UNCITRAL model law. Philip will correct me if I'm wrong, but Kuwait has not adopted a version of the UNCITRAL model law. Instead, Kuwait's arbitration law is found in various provisions of the Civil Procedure Code. We were in a similar situation here in the UAE in relation to the federal level until this new law came into force in 2018. If we go to the next slide, I'm going to pause for a few moments and let Philip jump in, and he's going to drill down a little more on some of these issues I've been discussing in the Kuwait context.
Thanks, Tom. So we're going to take a few minutes here just to talk about Kuwait specific. You can go back to the next slide. Kuwait specific considerations. I'm not going to spend too much time because the idea here is we're talking regional and overall different things about international arbitration throughout the region. But as you know, based in Kuwait and through the ABCK chamber, you know, I figured it would be a good time to spend a little bit of time on the Kuwait specific considerations with arbitration. Kuwait is a signatory to the New York Convention. It is signed up to it, and that's good news. That means A couple things. That means parties can freely, choose that. Kuwait companies can freely choose that as arbitration as a means of dispute resolution, and foreign companies can be satisfied that if they go into arbitration, these awards will be regularly enforced. So Kuwait courts do regularly enforce the agreement of the parties to arbitrate that are contained in agreements. Kuwait courts will retain jurisdiction still under certain circumstances. So there are some circumstances where the Kuwait courts will ignore the arbitration provisions in a contract and will retain the jurisdiction if one of the parties files a claim before the Kuwait courts. For example, failure to properly assert your arbitration clause. What that means is if a party tries to ignore the arbitration clause and brings a claim before the Kuwait courts, if the other party that seeks to go to arbitration does not properly assert the defense right out in the first instance that it has the opportunity to, it could be considered waived by the Kuwait courts, and therefore it will retain jurisdiction. So it's important from a practice standpoint that if there is an arbitration clause and you in the contract and you do want to enforce that clause to go to arbitration, if there's a dispute and a claim is brought before a Kuwait court, that at the first opportunity you challenge the jurisdiction of the Kuwait court to hear the case based on the arbitration clause. Kuwait courts will also retain jurisdiction in certain circumstances where they determine that the clause is non-binding, and sometimes it's because the clauses are not drafted properly and they actually say non-binding or something that limits the enforceability of that clause itself. So these clauses have to be carefully drafted. Another one that we've come across in Kuwait over the years is choice of arbitration or court. So sometimes you'll see an option. Sometimes it's unilateral, sometimes it's bilateral between the parties, where the parties have the option to go to arbitration, and then there'll be a secondary clause below it that says if the parties so choose, they can go to a court of competent jurisdiction to hear disputes. Now, with that, based on court precedent that we've dealt with here in country, what that has resulted in our experience, is that the courts will ignore the arbitration clause to say it's not a binding clause on the parties, it's a choice, and therefore the parties have the right to seek arbitration. Now, if both parties agree to that clause, clearly it's a choice, and if you choose the Kuwait courts, they're going to retain jurisdiction. Where we see it more commonly is where you have one party say, we have the right to choose arbitration, but you don't, or we have the right to go to a court of competent jurisdiction, but the other party does not have the right. You have to go to arbitration. We've also found that the courts have rejected those arbitrations as not being binding on both parties. Therefore, Kuwait courts can assume jurisdiction over the matter. Extremely important is agreeing to staying on the same slide, actually. Yeah. Agreeing to arbitration is not considered a normal act or decision under the Kuwait Companies Law. So Article 46 deals with this. For those who are Kuwait companies and are familiar with Kuwait Companies Law, under Article 46, there's a number of acts in that Article 46 that say that basically it is not considered a normal act, and you need special corporate authority in order to issue or to agree to these things. And one of those things in Article 46 is agreeing to arbitration. So you must obtain the proper corporate authorization to include an arbitration clause in your contract. Now, what Article 46 basically says is that if it's not specifically, given the power to the manager or the board, I believe the language is manager under 46, then you have to get a shareholder resolution for that. So you need to be aware of this, because an argument can be made by a party to say our company did not have the requisite power and authority to bind ourselves to arbitration, and courts do look at this. We've seen court precedents over the years that said if the manager of the company has signed off on it, that does give them the power to bind. We also have seen decisions go the other way, especially more recently after the company's law has been amended over the years. So it's important to make sure that the corporate authorizations are checked, that if the articles of the company are the memorandum of association or the articles of the company are silent on the issue, that you get a shareholder or partners resolution. If it directs it to the board within the articles of the company, then that would be fine to get a board resolution, or if it allows the manager to make such decisions. We also couple this with a representation and warranty that you have the authority to bind. That won't necessarily save you when it comes to the courts assuming jurisdiction if they find that there was not the proper corporate authority. However, it could be a basis for a breach of contract and potentially have some recourse under that. Kuwait, as Tom said earlier, Kuwait has not adopted the UNCITRAL rules. There has not been that has not been implemented in Kuwait, and there are a number of provisions that apply to both courts and arbitration that are in the Kuwait civil code. So Kuwait will recognize and enforce arbitration awards if the following procedural requirements are met. And they're the same things that are required to enforce a judgment, except we're going to not talk about judgments now, we're talking about awards. And it's very important because of the New York Convention. So as long as the place of the arbitration where the award was issued is also signatory to the New York Convention, that they must be, so wherever the seat of the arbitration is, must be a party to the New York Convention. The award was issued by a tribunal of competent jurisdiction, so it had the right to hear this case. Parties were duly summoned and represented at the arbitration or had the opportunity to appear, so you have to show some proof that they were summoned properly. And they did have, that they were represented, or if they weren't represented, they had the opportunity to. Tom can maybe talk more about representation at arbitration, proceedings and how that works and whether defaults can be entered. I'm not an expert on that part, but under Kuwait law, they have to at least been duly summoned to the arbitration. The arbitration award must be final and binding. The award does not contradict any prior judgment or order rendered by the courts of Kuwait. So if there was a case that issued a judgment on the same issue between these parties earlier, and then there was a separate arbitral award issued, and it contradicts it, then it would not be enforceable. And the award does not contain anything in conflict with the general morals or public order of Kuwait. Now that last prong there is the one we have seen, I think, the most artistic lawyering in Kuwait in trying to challenge the enforcement of an arbitration award that's been issued. So we've seen that relied on, but I think most of the times when we're trying to enforce an arbitral award, the challenge that is usually brought, if it's not the party didn't appear or wasn't summoned properly, if they can show that, obviously, but usually that's not the case because that can be properly documented. But they usually come up with conflict with the general morals of public order. This is not to say in conflict with the general laws of the state of Kuwait, but it has to be in relation to the general morals or public order. So we've seen that brought, in dispute of the enforcement of awards from time to time. But it hasn't always been successful because you do have to show that it's in serious conflict with these general morals or public order. Kuwait government contracts. So a lot of you do government contracts. I know a lot of the members of AmCham Kuwait are contracting companies that do work on public tenders and whatnot. And I just throw this in there just as a practice note, because most government contracts in Kuwait contain Kuwait law, Kuwait court provisions, and they're not going to be able to be negotiated out. Those are pretty standard in Kuwait. They don't really diverge from that. However, there are some exceptions, and we see most of the exceptions on the mega deals or the mega projects. For example, the PPP law does call for, allow for arbitration, I should say, within the law itself, so long as it's approved by the higher committee and whatnot. So there are some exceptions to that, although it's very rare on your general public tenders to see arbitration or foreign law. It's usually Kuwait law and Kuwait courts. So that's just a very brief synopsis on some of the Kuwait law considerations, and we're going to send it back to Tom to talk about the seat or place of arbitration.
Okay, great. Thanks, Philip. Just a few words on the seat or place of arbitration. This sort of ties into some of the concepts we were discussing earlier, and I kind of want to use it to set up a point I'll be making later. But you often see, and you should see, in terms of best practice, a reference to the seat or legal place of arbitration in an arbitration agreement. The seat, the legal seat or legal place of arbitration is important because it does two or three key things. Number one, it determines if the New York Convention applies. But as I said earlier, it now applies in 169 countries across the world. So that sort of goes without saying. I think more importantly, the seat or place of arbitration determines what the procedural law of the arbitration will be. In other words, it determines which of these national or jurisdictional arbitration laws we were discussing earlier applies. And therefore, it also determines which courts have supervisory jurisdiction over the arbitration. This is important because it determines the jurisdiction and the courts before which the arbitration award can be set aside or annulled on those narrow jurisdictional, procedural, or public policy grounds that we discussed earlier. Now, other courts can come into play at the enforcement stage. So if you have an arbitration seated in New York, the New York courts would have supervisory jurisdiction over the arbitration. They'd be able to determine if the award should be set aside or not. But if a party brings that award to Kuwait or Bahrain or the UAE for enforcement, those courts can also consider whether the award should be enforced or not, and will base it on these grounds that we've been talking about. One point that's important to bear in mind, and sometimes this result or some ambiguity results based on the drafting of an arbitration agreement, but the seat or place of arbitration is not necessarily the same as the venue of the arbitration. So a lot of times we might see that an arbitration has a legal seat, say in London, for example, but maybe the parties or arbitrators are based out here in the region and the hearings are held in Dubai or Bahrain or Kuwait City. Broadly speaking, that's perfectly fine. The hearings do not have to take place in the legal seat of arbitration. The tribunals have a lot of flexibility in where they hold the hearings. Often in practice, the hearings will take place in the seat, but they need not to. And of course, over the past 2 years, very few hearings have been taking place in the seats because virtually all the hearings have proceeded remotely online. If we move to the next slide, I want to talk briefly about the administration of arbitrations. Broadly speaking, there are two ways to go about it: have an ad hoc arbitration or have institutional arbitration. In ad hoc arbitration, your arbitration is conducted without having an arbitral institution in place to administer that arbitration. So the parties are sort of left to their own. They have to agree ideally on procedural rules. If they don't, the arbitration proceeds under the national law of the seat of arbitration. Often when we're talking about ad hoc arbitrations, the parties will use the UNCITRAL arbitration rules. Of course, these are different. These are more specific rules that have been promulgated by UNCITRAL for ad hoc arbitrations are different from the UNCITRAL model law that we were discussing earlier. My strong preference, and my advice probably 95% of the time, is that parties should opt for institutional arbitration because they can benefit from an institution providing that administrative support, more detailed procedural rules promulgated by the arbitral institution, and you have, generally speaking, more clarity, more guidance. The sort of the involvement of the arbitral institution varies to some degree across the board. And I think one key consideration in selecting an arbitral institution, there are many, but I think one is how that institution determines the arbitration costs. So how the arbitrators themselves are to be compensated and how the administrative fees of the institution are going to be determined. Some arbitral institutions do it on an ad valorem basis, so a percentage of the amount in dispute. The ICC takes this approach. The Singapore International Arbitration Center takes this approach. Others do as well. Others base the arbitrator fees and the administrative fees on hourly rates. The LCIA, for example, does this. There are probably pros and cons to both approaches. We can talk more about that later if people have questions, but I'll leave it at that for now. I'd like to go to the next slide. Now I'm going to try to get a bit more practical and talk about some of the options that are available when you're drafting arbitration agreements. Starting first with the international arbitral institutions. What you see here on the screen is by no means an exhaustive list. There are scores, probably hundreds of arbitral institutions around the world that can be used. These are some of the more common ones that we've seen. I would say the three I would say the first two, the ICC, the International Chamber of Commerce, and the LCIA are probably the two most common international arbitral institutions we see being used here in the Middle East. Globally, the SIAC is quite active as well. They've seen a bit of an increase in the number of parties from the UAE. ICDR, a little bit of a bias here because it's a US-based arbitral institution, but at least from my vantage point, I haven't seen a lot of ICDR clauses in contracts here in the region. And then others, Hong Kong, Korea, Stockholm, Vienna. The last one, the International Center for Settlement of Investment Disputes, that's a little bit different from the others that are on the list. The others focus on international commercial arbitration. ICSID is used primarily for resolving investment disputes between investors and states, typically, though not always, typically arising from a bilateral investment treaty. If we move to the next slide, now if we're focusing in a bit more on regional arbitral institutions, probably the oldest in the region, at least that I'm aware of, is KRCCA, or the Cairo Regional Center for International Commercial Arbitration. I think it was set up in or around 1979. It has a long track record. I think last year they registered about 80 cases. The Saudi Center for Commercial Arbitration is a relatively new one. I think it was set up in 2016. My own view is that SCCA is one to watch. Even though it's a young institution, I think they have been doing a lot of the right things. They have a modern set of procedural rules, as do the others. They are collaborating with the ICDR from the United States in terms of providing training to their staff, advising on their rules. And so I think it adds a little bit of confidence that they have this support from an established international arbitral institution. Our firm's been involved in a couple of cases at the SCCA, and we certainly like what we've seen in terms of case administration. So this is a young one, but I think it's one to watch. I also think it's one to watch because just simply given the size of the Saudi market and other steps that Saudi Arabia has been taking in the last few years to encourage international arbitration. I think when I arrived in the region 5 years ago, there was quite a bit of trepidation amongst users of arbitration when it came to arbitration seated in Saudi Arabia. But I think this is changing, and I'd say is probably changing at an accelerating pace. The Bahrain Chamber for Dispute Resolution, also a reliable arbitral institution. I think it's got, similar to the SCCA, some sort of relationship with the American Arbitration Association. GCC, Commercial Arbitration Center, it's based in Kuwait. We don't see a lot of activity there. Kuwait Commercial Arbitration Center, I defer to Philip. At an international level, we don't see much activity. My understanding is that it is based more on domestic arbitrations. Abu Dhabi Commercial Conciliation Arbitration Center, or ABCK, is one that we see some Abu Dhabi government entities using, but sort of beyond that, not a lot of activity there. DIAC, Dubai International Arbitration Center, has been around, I think about coming up on 20 years now. And that's what I'm going to be talking a bit more about in the following slides. Of course, the last one on this list is in brackets. That's not a typo. I didn't forget to remove those. Those are there for a reason, and that is because of the recent decree that was issued here in Dubai in September that I'm going to say this is shorthand, but I'll explain in a moment why this isn't quite accurate. But the decree has effectively abolished the DIFC-LCIA Arbitration Center. Now, if we go to the next slide, I'll explain why that's not quite accurate. Maybe it's accurate because I've said it has effectively abolished it. What this decree did, decree number 34 of 2021, which, as I said, was issued in September, came into force on the 20th of September 2021. what this decree did was it abolished two arbitral institutions. One, it's sort of straightforward. It was the Emirates Maritime Arbitration Center, which, as its name implies, focused on maritime disputes, had a relatively small caseload. I think they were only administering 2, 3, 4 cases. But the decree also abolished what's called the DIFC Arbitration Institute. And I don't want to get too detailed here, but effectively, what the DIFC Arbitration Institute is, or the DAI, was an institution in the DIFC that entered into a joint venture agreement with the London Court of International Arbitration to set up the DIFC-LCIA. Now, the reason I say it's not quite accurate to say that this decree abolished the DIFC-LCIA is that the DIFC-LCIA really was just a joint venture. It was not a separate arbitral institution with its own legal personality. The DIFC-LCIA was a joint venture between the DAI and the LCIA. So the decree has abolished sort of the parent entity, one of the parent entities of the DIFC-LCIA. But certainly the intention is that the DIFC-LCIA will no longer proceed. Its cases and property and lists of arbitrators and so on will be transferred to DIAC, the Dubai International Arbitration Center. And the decree was supplemented by a new statute for DIAC, which sort of reboots it. We sometimes refer to it as the creation of DIAC 2.0, addresses issues relating to DIAC's objectives and governance structures, and forms a court of arbitration for DIAC. So sort of the practical question becomes, well, what impact does this decree have on existing arbitrations that are ongoing at the DIFC-LCIA? And what does it mean for the contracts that are out there, live contracts that call for arbitration of the DIFC-LCIA? And I think if sort of given the success that the DIFC-LCIA had, there are probably literally thousands and thousands of contracts out there that provide for DIFC-LCIA arbitration. If we start with sort of the first, what's the impact on existing cases? I think that's probably where the least impact of this decree is. The decree states that any ongoing cases will continue under the existing rules. So will continue under the DIFC-LCIA rules, though administration of those cases will be transferred from the DIFC-LCIA to DIAC. In terms of new cases, it's a bit unclear, and I have to say we're still in the 6-month transition period that's referenced in the decree, and a lot of uncertainty remains. What we're seeing on the ground is that if you want to file a request for arbitration under the an arbitration agreement calling for DIFC-LCIA, and you file that with DIAC, they will still tell you at this stage to file it with the DIFC-LCIA. If you try to file it with the DIFC-LCIA, they'll say, look, we will accept it, but we can't register it given the uncertainty that's going on. So new cases are coming to a bit of a standstill. Again, we are optimistic that sort of a practical solution will be worked out within the next month. The 6-month transition period ends on the 20th of March. So we hope to have further guidance by then. In terms of arbitration agreements, existing arbitration clauses in contracts that are out there, what do you do? What's the impact of the decree on those? The decree states on its face that those arbitration agreements remain valid, but it provides that DIAC will substitute the DIFC-LCIA in the hearing and settlement of any disputes that arise under those contracts. Now, what exactly does that mean? I think at one level, it's pretty clear that DIAC will administer any disputes that arise out of those clauses going forward. It's not quite clear what's going to happen to any cases filed in the September to March period, but certainly on the face of it, the decree suggests that those are to be administered by DIAC. There's a little bit of ambiguity as to what procedural rules will apply in those cases. So if you have a DIFC-LCIA clause and a dispute arises next year, will it be a dispute under the DIFC-LCIA rules or the DIAC rules? The answer seems to be that if the case is filed before DIAC issues a new set of procedural rules, whenever that may be, then that case will proceed under the DIFC-LCIA rules. But once a new set of DIAC rules come into force, it'll proceed under the DIAC rules. My view is that this will be tested. I think there will be a lot of challenges to this decree, not just in the UAE courts, but in other courts as well. Practically speaking, what should parties do if they have DIFC-LCIA clauses in existing contracts? Look, every case is different and it depends, but the options seem to be option number one, don't take any action, see what happens. Some parties may be comfortable with the having a little bit of uncertainty until we get the new DIAC rules. And then may be comfortable to have those apply. We are seeing other clients, however, that want to have more certainty and are taking a more proactive approach in situations where the commercial relationship between the parties to the arbitration clause permits it. So if there is an ongoing commercial relationship, and that's an amicable relationship, we are seeing some of those clients proactively amending their arbitration clauses. You know, what they amend that to say varies, but probably most commonly what we're seeing is clients are switching to either the ICC or the LCIA in London. But there are other options as well. One last point I want to make in this regard, and then I am going to stop to see if we have any questions, is to just emphasize that this decree impacts the DIFC-LCIA as an administering institution. The decree does not impact the DIFC as a seat of arbitration. So the DIFC is still available to parties to seat their arbitrations in. The DIFC arbitration law that I discussed earlier has not been affected by this decree. We find that the DIFC courts are quite arbitration friendly. And so what a lot of our clients are doing is they may amend the arbitration clause to use ICC or LCIA, but they will keep the arbitration seated in the DIFC, and that does very much remain an option. With that said, we have seen some clients move the seat as well. The situation has left them a bit unsettled. Some clients have moved the seat to London. Some have moved it to the ABCK-AmCham, the other free zone in the UAE down in Abu Dhabi. But broadly speaking, what we're seeing in practice is that most clients will keep the DIFC as a seat. So let me stop there. I think we, both Phil and I, but mostly me, have thrown a lot at you over the last 45 minutes or so. But let me pause and see if there are any questions, or Phil, if you have anything to add.
No, I don't think there's much to add. We can go to Q&A and see if anybody has any issues they want to bring up.
Thank you so much, Thomas and Philip. So we do have our first question. When would you suggest that a company or an entity starts their arbitration process?
That's a good question. That's a very broad question, right? Because it really depends, right? It depends on the situation on the ground. It depends on the dispute. It just depends on sort of if there's any prospect for amicable resolution, if there's any prospect for settlement. Sometimes you can use the threat of the arbitration process to put pressure on the other side, recognizing that it often will be a time-consuming, expensive process, and many parties will want to avoid that. By the same token, you may not want to start the process too early if there is hope for arbitration, for amicable resolution. I think this is why, if you go back to those statistics, we don't have to put them back on the screen, but if you recall those statistics I shared earlier, I think it was 51% of those surveyed, those corporate counsel surveyed, said that they like their preferred option is ADR, which is presumably mediation with arbitration. And that gives the parties an opportunity to try to resolve the dispute amicably before going on to arbitration. The other point I would mention in this regard is that once you formally commence the arbitration process, once you file the request for arbitration, you do lose a little bit of control over the process, especially if the counterparty files counterclaims. And so you just have to bear that in mind. Often you may if you start the arbitration too early, it may spin out of control and you can't use it as effectively as you thought. The last point I would make here is that I think it does benefit parties to prepare for arbitration as early as possible, as soon as a dispute arises, so that once the trigger is pulled, they're ready to go. So, that preparation behind the scenes, the other side doesn't need to know you're preparing it, doesn't need to know you've retained lawyers, but the more prepared you are once the arbitration starts, the better.
Thank you so much, Thomas. And then we have our final question for the hour, because we do want to keep in mind people's time. Why parties seeking to agree to arbitration in the Middle East should no longer include the DIFC, LCIA, or EMAC rules?
Yeah, no, so this is a very good question. The short answer is it's sort of implicit in the question, I guess, or the first point is implicit in the question, and that is to sort of state this affirmatively. Parties should not use EMAC or DIFC, LCIA rules in arbitration agreements going forward. There is a real risk that any arbitration agreements entered into going forward will be viewed as void if they list these rules. There is the possibility that the arbitral tribunals and courts will conclude that a reference to these rules is effectively a reference to the DIAC rules, but I would avoid, when you're drafting arbitration clauses now, using the DIFC, LCIA, or EMAC.
Thank you very much. So would you like to add anything else, sorry?
No, sorry, I was reading the next question already, which is another good one.
Okay, if you'd like, we can tackle that next question, but as I mentioned, people might start leaving, so we still have the recording. So whoever has to go now, please feel free to do so. And you can just watch the recording to get the answer to this question. So Thomas, please go ahead.
Yeah, so this question is a good one. Any idea what was the objective in abolishing the DIFC, LCIA, perhaps to increase the popularity of DIAC, and whether that purpose has been defeated by parties abandoning UAE arbitration institutions and using LCIA, ICC? I mean, that's a good question. I think if you step back, conceptually, what Dubai has done makes sense at a certain level. There are a lot of arbitral institutions in the UAE. There are several just here in Dubai alone. And I think the idea was that some consolidation is appropriate. It is better to have one strong arbitral institution that Dubai can sort of rally behind, develop, and market to compete with the likes of the LCIA, ICC, and SIAC. I think the challenge has been the manner in which the decree has been implemented, and I think it's just, as I've alluded to earlier, has created some uncertainty and has led some parties to opt for arbitral institutions, at least for the time being, outside of the UAE. My hope and expectation is that DIAC let's put it this way, DIAC 2.0 will be up and running soon. It will issue a new set of arbitral rules soon, and it'll really remedy some of that uncertainty that we're seeing during this period. It's too soon to tell, but I have every expectation that the DIAC rules, which need to be updated, they haven't been updated since 2007, but hopefully they will be issued promptly. And I have every expectation that they will be a modern, state-of-the-art set of arbitration rules. So hopefully we will be able to move past this period of uncertainty and get back to where Dubai needs to be on the arbitration scene.
Thank you so much for your feedback and your crucial input, Thomas. All right, so since we've reached the hour, I would like to now give the floor to Pete, our chairman.
Wow, what a great presentation. So much wonderful information. I'd like to thank Philip and Thomas for their time and the wonderful information that they shared. I'd like to thank all of you for joining, including Abu Dhabi and Bahrain AmChams. And as always, I need to thank our team, Paola, our ED, Samir, Jensen, and Emma for all their hard work in putting these events together. And if you have a need for arbitration, please reach out to the Al Tamimi office nearest you. Thank you all for joining us, and be safe and enjoy the holidays coming up.